Good morning, members. This is the appointed time. We have a quorum. So I call this meeting to order. This is the meeting of the Bills Committee on the Basic Housing Units Bill. Now we'd like to make use of this meeting to discuss the CSAs to be proposed by the government. We completed the clause-by-clause scrutiny, and the government also provided written responses to the issues raised at previous meetings. Members have asked for an additional meeting to discuss these follow-up items. So that's the background of today's meeting. In relation to the items raised at the four previous meetings dated the 18th, 21st, 22nd, and the 25th of July, the administration provided written responses. I'm not going to read out the paper numbers. Please refer to the agenda. The administration also provided a consolidated response paper to the views of deputations and individuals. So there is also another paper about the proposed CSAs. So for housekeeping, may I suggest the following? If need be, we can discuss the administration's written responses and also the consolidated response to the views of deputations and individuals. And then, when this is completed, I will invite the administration to go through the proposed amendments. Any views? If not, I will invite members to press the button now. If you want to speak, I'll give each member 4 minutes, questions and answers included. And please introduce which paper you'd like to refer to before you speak. Mr. Tony Jia has a question, I see, so 4 minutes each. Questions and answers, please. Thank you, Chairman. I thank you for acceding to my request and calling for this meeting, because I do think it is necessary to go through certain items. The first one relates to the issues raised on the 18th of July, and that's about the provision of water supply points and sinks outside the toilets in SDUs. Now, I don't have any strong views about the response, but I think that some SDUs in the future may not be able to meet this requirement. In particular, I'd like to talk about waterproofing. The problem relating to water supply points and sinks outside the toilets is that we need to consider sewage and drainage, and that means connections are of utmost importance. Water leaks may not be detected there and then. So in terms of waterproofing for floor slabs, I think a more relaxed approach should be taken, also because of the habits of the users. And previously we talked about methods such as injection. I had this experience before. After performing injections, the water seepage might spread elsewhere. So my point is that waterproofing for the toilets in particular should be improved so as not to cause salt water seeping to downstairs. My next question relates to CB 11267/2025-01. That's about the response to the issues raised on the 21st of July. And in this paper, it is said that at the time of the tenants passing away, the family members should be living together with the deceased tenant in the subdivided unit. My point of clarification is whether we need to spell that out in a tenancy agreement, because it's very difficult to prove where should we draw the line. Is it all right for the family member just to live with the tenant for 2 or 3 days on a short-term basis? We do need clarification. Deputy Secretary, Ms. Wong. Good morning, members. Thank you, Chairman, and thank you, Mr. Chair, for the questions. About water supply points and sinks outside the toilets and waterproofing, in the detailed guidelines to be formulated, there will be more specific requirements. And I thank Mr. Chair for the reminder. Of course, we need to make sure that connections are properly put in place, and we'll also adopt a relatively more relaxed approach towards waterproofing. So I thank members, and we'll definitely consider this view in the formulation of the COP. The second point relates to family members. That is a general understanding of what a family member is. It's not about how long this family member lives with the tenant. Say if it's a father or a mother signing the tenancy document and that the tenancy agreement does not show the names of the children, the children in a general sense, of course, would still be regarded as family members of the tenant, and in this circumstance, in terms of succession rights, the children will still be entitled to the legal rights. I have a question about the items raised at the meeting of the 22nd of July, and that's 1226. That's a paper number. About the legal backing for the secretary to make a direction to cancel the tenancy agreement, or otherwise the tenancy agreement being automatically cancelled. Now I have some comments, because this is about protecting the accommodation or living environment of the tenant, and I must emphasize that for tenants living in a factory or building or unauthorized building works, the SDU tenant does not enjoy the legal protection. So if the line is to be drawn here, I want to emphasize that the protection is not for everybody. Another point about paragraph 12, you refer to the relevant ordinance, and that relevant enabling provisions are provided, but I'm not quite sure the legal basis. I'd like to invite the administration to elaborate on this. Mr. Lam, made a very good observation. Indeed, we explain in detail in this paper why under some circumstances the Secretary must exercise the power given under the ordinance to terminate the tenancy agreement. We understand the members are concerned about the legal basis. So despite this detailed written response, I'd like to further explain orally. Now, we must go back to the original intention. In 2022, we wanted to regulate subdivided units. The policy objective is to provide tenancy protection for SDU tenants. So the bill was passed, and it becomes the Landlord and Tenant Consolidation Ordinance. Mandatory provisions or clauses are to be included in tenancy agreements, and that's what we call the 2 and 2. Simply put, after the landlord signs the first tenancy agreement with the tenant, regardless of the period stated, upon passage of the 2022 legislation, we introduced a mandatory requirement that the first tenancy agreement must be good for at least 2 years. And upon expiry of the first tenancy agreement, there is an obligation for the landlord to provide a renewal of the tenancy agreement up to 2 years, and that's what we call the 2+2 protection. We seek to provide additional protection to SDU tenants, and this is our policy objective. We understand that in general, we should go by the terms and conditions set out in the tenancy agreement, but because of the additional protection necessary for SDU tenants, we introduce some mandatory clauses in 2022. We're now in 2025. We'd like to take this further. We need to do more to improve the living environment in general of subdivided units. We want to eradicate substandard SDUs in Hong Kong. So for flats operating subdivided units, we introduce the minimum standards, and only SDUs meeting the minimum standards would be able to operate and be leased. And that's for the policy consideration. There is a major problem we need to tackle. Now, coming back to this bill, there are suggestions that the Secretary is given too much power. Why is the Secretary empowered to direct the termination of a tenancy agreement, which is privy only to the parties of the agreement? We want to emphasize that if the SDU is not recognized or certified, that means the SDU does not meet the minimum standard. It's not a safe environment for inhabitation. The tenancy is therefore required to move out of the unit, and the Secretary is therefore empowered to terminate the tenancy agreement. It's not just about honoring the spirit of the contract. It's also for protecting the tenant. Say, under the 2022 legislation, since the tenant enjoys the 2+2 protection, if the tenant insists not to move out, it will be a catch-22 for the landlord. There is no way to evict this tenant, for example. And that is why we're giving the Secretary the power to consider the situation after the certification of the SDU has been cancelled. Now, without this certification or record, if the landlord continues to allow the SDU to be rented, then the landlord will be committing an offense. So there is a need for this power to be exercised to terminate the agreement for both the landlord and the tenant in question. And comparing to the 2022 legislation providing additional protection to tenants, we can address the differential approach in this 2025 BHU bill. Sandra Lam, please wait for the second round. We need to give time to other members as well. Mr. Vincent Chang, can you also explain, or can we also discuss the administration's response to members of the public? And in fact, I read all the 41 written submissions. They're basically 3 parts. In general, there is support for this bill to tide SDU tenants over. The bill comprises minimum requirements and standards in relation to size of ventilation and space for children, and I think this is a good idea. I'm very touched by some of the written submissions, such as one from Mr. Leung, the school principal, and also some NGOs also support this bill. They operate transitional housing. Now, the third part relates to those running the business of SDU, they in principle provide support, but I think that you need to address certain details. For example, in relation to structural safety, in particular loading in the paper, it is said in the paper that professionals will have regard to the actual situation in relation to the materials used for floor slabs, etc., in determining whether the BHU is in compliance with the loading requirements. Now, can you tell me more about that? Will guidelines be provided? Some SDU operators are concerned that when the rubber hits the ground, in the end they may need to conduct numerous checks. Second point about water meters or electric meters. I think the utility companies are willing to help, but there are difficulties in identifying the right locations. So when it comes to implementation, please provide help.
Ms. Wong, there are two questions about the structural safety. Indeed, during the consultation period, there have been questions about the calculation of the structural safety, that is the capacity. Regarding our requirement towards the authorized persons is relying on their professional knowledge. Generally speaking, for SDU, maybe they will lift up the floor screening and make use of partitions. These are all some additional weight, but they can be just minimal. As we communicate with the buildings department, we understood that it will not add much loading to the original unit. Likewise, as we live in our apartments, we will add some cabinets and they carry similar weight to those partitions. In our guidelines, we will try our best to provide as many details as we can. There will also be examples serving as references for the professionals. Second, about the electricity and water meters. We did receive a lot of opinions and questions about the location of those meters. For the electricity meters, although they may not be able to install such meters within the SDU, they shall be able to find such space in the original apartment. As we communicate with the provider, they said that there are some electronic meters that does not have to be attached to the SDU. I think it will not be that difficult for us to look for an appropriate location. Mr. Lam Chen Sing, thank you, Chairman. I want to follow up on the questions of Vincent Chan, that is the individual electricity and water meters. According to the general public, there have been some concerns in this regard. First of all, if there are many units to be recognized, then the WSD and the companies might need to renew tens and thousands of those meters. Will there be sufficient manpower? Because we have renewed the water supply facilities ordinance. And the Water Supplies Department have been encouraging the operators to install independent meters, but the response has not been as encouraging as we expect. In this ordinance, it is mandatory. My question is, do you have enough manpower for installation? Would there be delays? Because if there is delay, then the the recognition will also be delayed. Second, Mr. Vincent Chan has rightfully put it, the Electricity Association have worked together with the electricians who collaborate with those apartment owners. Since there are requirements about the locations of the electricity meters at its height, if they can look for an appropriate location within the original apartment, that will be fine. However, under circumstances, they are unable to look for such space and it needs to be installed in the public areas. In the future, when they have to renovate the whole apartment, maybe they are able to look for such space, but it might still be difficult for some, and they have to install it in the public spaces. If that is the case, if it is being allowed by the owners organization, or if it is allowed by the deeds, would that be acceptable as well? If not, there might need to be some coordination from the Home Affairs Department. Ms. Wong? Mr. Lam worried about the installation of electricity and water meters. They worry that there might not be enough manpower from the WSD and the electricity companies. Actually, we have a long period of time. Since the 1st of March 2026, we will begin the registration. All the existing SDU will have 36 months of grace period. That is a total of 48 months. In other words, 4 years for them to revamp their units. I believe that is sufficient time and manpower for the installation of meters. We are also in touch with the utility companies as well as WSD. They are fully aware of this requirement of the installation of electricity and water meters. They will also be very cooperative. I trust that we will be able to complete them. Second, if the owners are unable to look for an appropriate location, your question is, can they install it in the public space? Then it depends on the deeds as well as the opinions of other owners. It will be difficult for me to give a response to you specifically. As you have put it, if they're going to revamp the whole apartment, it will not be that difficult for them to leave out space for the installation of meters. Thank you, Chairman. Mr. Low Wai Kwok. On the 25th of July, at our meeting, we have raised one question that is rather significant. Well, for the recognized basic housing unit, if they are no longer letting, then they no longer needs to be recognized. Shall the BHU be returned to its original format? Because many requirements of BHU the requirements under this bill is more lenient to the existing building ordinance, including the height and the existence of a kitchen, as well as lighting and ventilation. I understand that it is difficult for the government to allow those units to continue to exist when it is no longer serving the purpose as a BHU. It is very difficult for the government to put it so explicitly. However, practically speaking, although the BHU is more lenient than the existing building ordinance, at least it is safe. The requirements of the existing basic housing units bill will not cause safety hazards. In your written response, you said that maybe we have to exercise certain power given by the building ordinance and to adopt a risk-based approach to take care of those structures that might cause immediate risk or hygiene or safety hazards. Well, generally speaking, even if the owner no longer wants to be recognized as a basic housing unit, those risks, those hazards shall not exist. However, to these owners, they ought to understand this responsibility. I just worry that because the owners might not be aware of that. There isn't much discussion in this regard. I don't think many have noticed that if I choose not to operate as a basic housing units in the future, I would carry such responsibility. It is likely that I have to demolish the structure that I installed in order to fulfill the requirement here. And I also worry that some owners might be hesitated they might expect that their children might live in the unit here in the future. But before they have to move in, I can use it as a basic housing unit and generate some additional income. In the future, if they're going to use it for self-use, they might risk violating the ordinance. I believe that the owners need to be aware of that. From our discussion at the last meeting, as well as today, I think what has been shared by the government is very important. Well, you cannot say that the owners no longer needs to adjust the newly added structure in order to fulfill the requirement of basic housing units. This is not something that you can explicitly communicate it, but I believe that what I have explained are some minor obstacles in this regard. Thank you. This is a new questions that we failed to notice before. I believe, Ms. Wong, when you brief the public about this, you have to take note of that. The owners needs to be aware that if they stop to apply for recognition, they might need to restore the structure within the unit. Anything you need to add? Let me briefly respond. Thank you for the comments from Mr. Loh Wai Kwok. After the long discussion at the LegCo, we did communicate it with the Development Bureau as well as the House Building Department. When the unit is no longer recognized as BHU, theoretically speaking, they are not going to enjoy the exception clause in clause 72 and 73. As mentioned, the execution of law, the law enforcement of the building department is risk-based. We have to see if there is any imminent danger caused by those structures. I'm also grateful for your reminders. In the future, as we promote about this ordinance, we will highlight it so that the owner will be aware. Ms. Starley. Chairman, I have a number of suggestions. First of all, on the 18th of July, we have mentioned about the water supply point and the likely risk of water seepage. I am quite experienced in the aging area. Actually, a lot of basic housing units are being suspected for water dripping or water leakage of the unit downstairs. So apart from avoiding such risk, I trust that before they have signed any documents, there needs to be some reasonable inspections. You also need to be more pragmatic in your considerations. If there have been some existing complaint before they are recognized, will you also pull it into your considerations? Will you require them to fix it before they can apply for your recognition? Second, during the operation of BHU, if there is another complaint, would it be taken care of by the FEHD? These are some very practical issues. I hope that you can clarify it. But I think with the recognition system, it will be much better than what we have right now. Second, about the separation of electricity and water meters. This is what we understand. I think it is only fair for us to split it up. And recently, I also concerns about the suspension of electricity supply. Because in the recent case, we discovered that there are apartments that are divided into 7 different units, causing the outage of electricity supply. I hope that in the code of practice, you can also require the professionals to look into this. They need to properly arrange the electricity supply so that individual use will not be much higher than the supposed reasonable range of each unit. If there is any such requirements, I hope that you can give us some details. It is actually very complicated for us to manage the aged buildings. Well, from the EMDD, from the Fire Service Department, and now the you also have the Urban Renewal Authority and also the housing departments right now. I'm not sure if you can well coordinate among yourselves.
Well, thank you, Ms. Lee, for these questions. The first is about water seepage and water dripping. The specified professionals will be required to prepare a report. The report will be based on their professional judgment. That means there will be visual inspection of any water seepage in a flat, and landlords are also responsible. And that is, if the government department has been notified of water seepage, the owner is responsible for providing information to the government for handling. So that's about the stage before the recognition. And if the water dripping problem is verified, I think the FEHD will be the first department to receive this complaint, and there will be further communication. In the coming 5 years, the basic housing unit will continue to be required to comply with the minimum standards. So if water seepage or dripping of the SDU concern causes a major problem to the neighboring units, we don't rule out canceling the recognition. The second question is about the water and electricity meters. Before installing the meters, there will be checks on loading and the integrity of the electricity circuit. And only when everything is sound will the power company install the meter for the SDU. About coordination, well, in fact, we have a new initiative. The Deputy Financial Secretary is responsible for subdivided units, and there is a team under the Development Bureau comprising Fire Services Department as well as the Buildings Department, and we have regular communications, and we'll keep this in view. Mr. Lam Meng Kwong. I have this first question to follow up on the provision of water supply points and sinks outside the toilets. Now, we previously discussed this issue. I understand in the future, details will be set out in the Code of Practice or the guidelines. However, it's very important that you provide sufficient details in your guidelines about compliance matters. Well, I want to know more about what will be included in your guidelines. For example, about water supply points, it's said that waterproofing will be necessary. Can you tell us specifically how large of the waterproofed area should be put in place? And if water seepage occurs, and if it's not possible to stop the water seepage immediately so as not to affect neighboring units, will there be specific requirements about the time frame for water seepage to be addressed, to be included in the guidelines in the future? The next question is about power issue, as mentioned by Starry Lee. In fact, in Tai Kok Tsui, I am also handling a case. This building has about 400 units, but there are also some 60 flats with subdivided units. So instead of just having 400 households, this building now has 200 to 300 additional households. As I understand, for installation of meters, they go by the owners' corporation's views or the deeds of mutual covenant. But now I heard about the new technology, and that the power company would check the relevant loading to see if it's in compliance. However, there are now 200 additional units in this building because of SDUs. If they all turn on air conditioning at the when night falls, the power company may not be able to handle this ad hoc incidents immediately. I want to ensure that safety is guaranteed. Ms. Wong, about the provision of water supply points, the member asked about what details to be included in the guidelines. In fact, we do provide a lot of details. The details even come with a visual diagram. If need be, I can further talk to the member after the meeting. So, of course, we will be providing clear guidelines for professionals. Second point, when an electric meter is to be installed, the professional would check the relevant unit as well. The power company will do the same. If individually the unit's power consumption does not exceed the overall loading capacity, then for the whole building there shouldn't be any problem. But as I mentioned, for example, in this incident, the problem of short circuit occurred because individual tenants have come up with different ways to connect to the power supply and thereby cause the power outage problem. So we'll definitely require the power company to conduct checks for compliance before meters are installed. Ms. Doreen Kong, I'm concerned about the definition of the operator. Whilst I understand the administration's response, and since this operator will be charging rent, the operator should shoulder some responsibility. However, Chairman, I want to emphasize that for other parties such as banks, trustees, etc. Well, you talked about a defense being available, but we are an international financial center, and large corporations may not be operating BHUs. Rent charging activities, after all, are prevalent in Hong Kong. And Chairman, I must also emphasize the other point, and that is we have some elderly owners who are quite aged or having cognitive decline, and these elderly owners may have received some court orders. Now, under mental health ordinance, let's say if this owner has signed an enduring power of attorney, or under the mental health ordinance, if a guardian has been appointed to collect rent on that person's behalf, then the person could become an operator. Then will exemption be given to this proxy? Chairman, we must not ignore the problem of the aging population and elderly owners. I'd also like to respond to the issue raised by Dr. Starry Lee about power supply. Voltage fluctuations or power outage are actually common scenarios in old buildings or buildings with many units. We need to consider very carefully in taking forward basic house unit regime, because when it comes to building management in the future, there could be litigation. In theory, every owner has the right to apply for power connection. But because of BHU recognition, if some owners are not given the right to power connection, then this could be litigation hazard. Now, why don't you pause here, Ms. Doreen Kong, so that Ms. Wong could answer your question. All right, Ms. Wong. Thank you, Chairman. Thank you, Ms. Wong, for the questions. The first question relates to the operator. The question was whether we will revise the definition to include banks and other trust companies which could charge rent or collect rent on behalf of the owner. Now, as explained before, the original intention is that if you engage an agent to collect rent, the agent will have a duty to know what exactly is happening in the unit. One example is mortgage in possession. In this circumstance, this owner may have mortgaged the flat to the bank, and that this flat has a number of subdivided units or basic housing units, and because of default in mortgage, the bank then repossessed the flat, and after repossessing the flat, it is possible that this bank might sell the flat. The bank in question may not want to continue with the BHU business. So we need to be pragmatic in considering the actual circumstances, and we may not therefore initiate the litigation against a bank because there are resource implications. The member also mentioned elderly owners and the enduring power of attorney documents. As I understand, if an EPA has been signed, the person so authorized could make certain decisions on behalf of the elderly owner. Now, if this authorized person has knowledge of the basic housing unit, then this person may invite the tenants to leave and cease operation of the BHU, or this authorized person may become an operator to continue with the BHU business. Well, we believe the existing definition of owner should capture the majority of scenarios, but as mentioned before, and if this person so authorized under the EPA has exercised reasonable steps to cease the operation of BHU, but time is needed to meanwhile, then we will consider the actual circumstances. Now, turning to the next point, I think members are all concerned about power supply problems in old buildings in Hong Kong. Owners operating BHU will need to ensure that the basic housing units are in compliance with the requirements, and after recognition, our Bureau will also consider the overall situation of the building, and that departments may be consulted on various issues such as power supply. So we will take a holistic approach in considering applications. Let me remind members that when you put your questions, please make sure there is sufficient time for the administration to answer your questions. Ms. Jovi Chan. Thank you, Chairman. I thank the administration for taking on board our views as set out in their response to the FTU's questions about submitting forms to provide information to the government. The owner will, to his best knowledge, fill in the form in order to make this report. The government should also mount publicity and encourage owners to put in as much information as possible so that the original policy objective of policy alleviation can be met. The second point is that I understand the Labor and Welfare Bureau is now compiling a database of carers so as to identify high-risk carers. So my question is this: after receiving information about high-risk carers through the exercise, will the Bureau share the relevant information with the Labor and Welfare Bureau so that the carers can get a timely and adequate help.
Thank you, Chairman, and thank you, Ms. Chen, for your question. As you can see in our response, if the owner is letting a subdivided unit, the owner has no power to require information about the number of persons living in each SDU. Therefore, we cannot ensure that owners will be able to provide the age or the number of people living in that particular unit. Your request has been noted. We will try our best to collect information. In the application form in the future, we would ask the applicant to fill in such details. In the future, as we promote about this ordinance, we will also encourage the owners to provide such information. However, we will not disregard his application or impose any criminal consequences if they choose not to. We also understand that the Labor and Welfare Bureau is collecting data about the carers. Well, as we are imposing the BHU ordinance, we have to collect data to a certain objective or for the purpose of implementing this ordinance. Therefore, it will be quite difficult for us to pass on the owners or the residents' information to the LWB. But we do collect big data. Let's say in a certain area, there will be a number of people falling within a certain age group. We will be able to create such big data, and that would be the data that we can share with the Labor and Welfare Bureau. As mentioned in the previous meetings, the community living room that is promoted by the LWB shared a similar objective. We are all here to help the residents of SDU. In that case, we'll be able to share the big data we have with them. Next, Reverend Peter Kuhn. Chairman, I noted that many members are concerned about the issues of water seepage or the supply of electricity. Since we are going to require them to apply for recognition, we will also require them to purchase insurance for their own units. At least in the case of water leakage, when there is claims, it will be much easier for the residents downstairs to make claims. Thank you, Chairman, and thank you for your question, Reverend Kuhn. There have been some previous discussion regarding BHU. The letting of SDU is a private tenancy market. As the government, if we are imposing any restrictions there, we have to carefully consider to see if it is of necessity. Since you have suggested about the purchase of insurance, well, I think we cannot make it mandatory. Your comments is noted. In the future, during publicity period, we would encourage the owners to purchase insurance because it is actually beneficial to themselves. In case anything happened to the unit, an insurance will give them more financial security because it will be better for them in case of claims. Any follow-up? I think it will not be impossible for you to add such clause because the secretary can be empowered. The secretary can even be empowered to terminate a contract. Please consider it in the future. Now you only want to encourage them. I understand that if you have to add an additional requirements, there will be additional cost. But, if there has to be a subdivided unit, then there will be an additional toilet. Then the sewage might be changed. It might be right on top of the other living areas for residents downstairs. Perhaps you can carefully consider it. If you just put it in the code of practice, they may or may not do it. But this is something that is rather important to me. If not, that might be many claims. If it is an aged buildings, you might have to terminate the deeds, but it may not be that workable. Let's move on to the second round of questions. Mr. Tony Chan. Thank you, Chairman. One of the major reasons for me to support this bill is to take a pragmatic approach to replace substandard SDU phase by phase. I think safety is important. If they fail to fulfill our safety requirements, including the loadings, etc., if they fail to fulfill the safety requirements because they are already too aged, etc., then that would be an issue, and it has to be determined by the professionals if you allow them to continue to exist or if you allow them to divide among itself and let it will affect the residents living there and also the other law-abiding residents in that particular building. I support this bill because it is very practical. Well, because in case any accident happen, people will be pointing finger at the government, blaming us for doing nothing. I have a number of comments summarizing the public opinions. If you look at the statistic, we have the majority who support us, but those who oppose us are well organized. So the government needs to be clear in your explanations. Otherwise, people might speak words of threats and manipulate public's opinions. In your response, you said that the consultants have done some investigations about the minimum requirements, including the IFA. But other people would say that 70% of the existing SDU fail to fulfill such requirements. This is one example. In this case, perhaps you need to clarify it if they are speaking from no grounds. We also mentioned about power supply. It is possible that if it is overly divided, then that particular unit might be overloaded. It is difficult for the power supply company to accept that. Should it be done in a first-come, first-served basis because you are giving them a period of 4 years? If they are law-abiding, if they want to continue to operate SDU, the owners want to make more money. If you want to make money, you have to show that your responsibility. As for the rental level, it has to be determined by the market. I hope that the government can increase supply so that the market can be stabilized. As you know, generally speaking, the rents continue to rise. For those who cannot afford the increased rents because the living environment of the SDU needs to be improved, I hope that you will be properly supporting them. Being pragmatic is very important. So these are my comments. Ms. Wang, anything you would like to respond? Thank you, Mr. Chair, for your comments. We did conduct surveys and we have statistics on our hand, and we have been trying our very best to tell our story. After the ordinance has been passed, we will do more publicity so that both the owners and the residents would be well aware that there is a period of grace period for 4 years. So all the existing owners and residents should not be worried. We want to encourage all the SDU owners can speed up their renovation to apply for recognition. We do support such efforts, and we have a lot of support in place. We will increase our supply in public housing units. We also have light public housing as well as the transitional housings for category C. Therefore, we shall be taking care of the residents of different types of SDUs. Mr. Andrew Lam, thank you, Chairman. I want to follow up on my previous questions about the legal basis. I have never doubted the good intention of the government. The government wants to tackle the risk as well as the responsibility of the owners. But we're talking about the legal basis here. Let's say there is a transaction of a housing unit. As long as both parties agree, then even if there is an unauthorized structure in that apartment, the transaction can still be completed. If the contract is in violation of the legislature, then any particular party of the contract can also sue the other party. But now we are talking about empowering the secretary to terminate a contract. We are talking about a completely different level, and that's why I have to ask about the legal basis. Your response has been taken, but I still have my doubts, and I don't know how can it be dealt with. Therefore, I would like to repeatedly remind you about this. I hope that in the future you will not face challenges about this power that is being given to the secretary when you have to enforce it in the future. Well, when I look at your response and when I look at the landlord and tenants ordinance, from my judgment, I don't think it is fully applicable. Second, about the deed, that is the responsibility of the landlord to clarify. If we are talking about the fulfillment of the safety or the other items, we have prescribed professionals. It seems that we have presumed that the landlord needs to seek help from the prescribed professionals. But for the fulfillment of the land deeds, it seems that they don't need to seek any help from experts. Will it cause any execution problem? Especially we are talking about a lot of elderly. I hope that when you design your form, there will be some very clear support, especially regarding those statutory requirements. Some colleagues have mentioned about certain mandatory requirements. In case the purchase of insurance has become mandatory, you have to be very careful. Strictly speaking, if a particular residential unit is in violation of the building ordinance, then would it be possible for them to purchase insurance on discount? This is something that we have to take note of. Ms. Wong, thank you, Chairman, and the questions of Mr. Lam. We understand the concerns of Mr. Lam. According to the contractual law, the contracts, the termination of the contracts needs to be determined by the contracting parties. That is why we want to provide this legal basis for the secretary to terminate the contract. We want to fulfill a legal objective, and I believe that it is legally sound. Regarding the DMC, since it is the landlord that is applying for the recognition of BHU, we believe that they need the help of the prescribed professionals to see if they have fulfilled all the 8 requirements. But for the DMC, I think the landlord himself has the responsibility to find out the details of their own DMC. You asked about the elderly. They might have difficulties understanding their own DMC. If they want to operate a BHU, they may need some legal professionals' help to find that out. But that is only one possibility. If they are not sure, they can also choose to let out the unit as a whole without dividing it. Your opinions have been noted. As I have set out in the documents, in the future forms, we will require the landlord to make a declaration confirming that if they are going to apply for the recognition of BHU, they have to make sure that it is in line with the related DMC. If there is any false declarations, proper law enforcement actions will be taken. Ms. Darley, I think you are too ideal. First of all, the general public will not be able to understand the DMC. If that is your requirement, then maybe the operation of BHU will be handled by some organized parties. When I was first becoming a legislative member, I find it difficult to explain it to the members. You have to explain to the general public that it is their own responsibility if they violate the DMC after acquiring a license from the government. They might not be able to understand them because they already acquired the license from the government. I think it would be very tricky for you to clearly clarify it to them. What you have explained is very ideal. Personally speaking, I think it is difficult for the general public to fully understand. Third, you also require the landlords to sign a declaration confirming that they have fulfilled the DMC. Those operators of BHU, if they are not organized, then many of them not only are grassroots level residents, they just want to have some additional incomes through the rents. I really doubt if they know whether or not they are in violation of the DMC. It is indeed difficult. Since you have some professionals in place, they will also be reading through the DMC. How about they can also remind the owners about any potential violation of DMCs? Well, because if you ask the landlord to show the sole responsibility of that, it would cause a lot of controversies. I hope that you can consider that. Because I think it will be quite complicated if you're going to execute it the way that you explained. I also have a follow-up question about water leakage. When you publish your guidelines, perhaps you can ask the professionals to inspect for any water leakage, and the owners also need to check if there is any letter of complaint. Is it possible for you to understand by talking to the residents living downstairs? Because it would be quite difficult for the professional to inspect it with naked eyes. I think over 50% or over 70% of water leakage can not locate the source. We just have to be fair. We cannot just blindly decide that the BHU is the cause. How can you enable the professionals to note the potentials of water leakage? I think this is something very practical that you need to talk with them. Finally, about what power supply. Perhaps you can respond to me first.
Ms. Wong. Thank you, Chairman. Thank you, Dr. Lee, for the questions. About the DMCs, of course, the member has experience in community work. In taking forward the BHU regime in the future, we will remind landlords to make sure that the minimum standards are met. And at the same time, the DMCs will not be contravened. In fact, the owners can get relevant information from the management office or from their lawyers. We need to strike a balance. While some people would like to operate basic housing units, other landlords in the buildings also have their respective rights. So if an applicant wishes to turn the flat into a number of basic housing units, it's for that owner to check all the relevant requirements. It's for the owner to make sure that the DMCs will not be breached. And in taking forward BHU recognition, professionals may be engaged. You may ask the professional to check the DMCs as well, but perhaps the fees may be different. So when the owner applies for BHU recognition, the owner may need to talk to a professional and to get opinion from a third party. As for the second point, water seepage, we will ask the professionals to get an understanding of the situation downstairs of the relevant unit, and we'll also consider including the details in the guidelines, see whether there are any other alternatives for meeting the same objective if there is a difficulty in the communication process. Reverend Peter Kuhn. I have a question about the professionals. I understand that in applying for a an electric meter to be installed by the two power companies, a form will have to be submitted. Well, in meeting the minimum requirements, you need to make sure that the building has sufficient power loading to support the installation of extra meters. This is the same for electric or chargers for electric vehicles. So specifically, how will the arrangements be put in place? Say, if you have 3 independent meters for 3 separate units, then on the whole there may be overloading of the system for the building, and this may be a departure from the original intention. Ms. Wong. Thank you, Chair. Thank you, Member. I am not an expert, but I talked to the power companies, and as I understand, whilst installing meters, the power company will not just consider a separate basic housing unit, but the overall loading of the flat in question. Say if the flat has been divided into 4 basic housing units, the power company would consider the overall loading capacity of the flat to make sure that by installing additional meters it will not go beyond the capacity. Right, Chairman, I'm not worried about overloading. I am not an expert. I respect your answer. I'm worried about another issue. Say if there is a 60A, but if the power company decides that it's not sufficient, that means you need to enhance the capacity, and that there may not be a sufficiently big plant room of the building to accommodate the extra facilities. I think it's a bit technical. When you install separate meters, there will be other requirements. Say it's not sufficient just to install 60A meters. You need to boost it to 120A, and that's some math for the professionals to do. Not all buildings are equipped with the necessary physical space to accommodate that. As I understand, in order to check up the power supply, the power company would consider the overall situation of the building. They would not just consider boosting the power capacity of an individual flat. So perhaps I'll go back and confirm the position with the power companies. And I think that the EMSD is responsible as well for the overall safety of power supply in Hong Kong. The overall objective is not to cause any issue of power supply to the overall building because of BHU. Now, Chairman, I think my question is that the power companies may tell you that it's not possible to install separate meters if the capacity cannot be enhanced because of physical constraints. That's my question. That happens to the EV charging at home scheme. Chargers cannot be installed because of lack of space in the plant room. This is like what Ms. Doreen Kong just mentioned. They're not able to apply for additional power supply for the ground floor shops all the way to the 3rd floor because of this reason. Ms. Wong? For the BHUs in that flat to be recognized, I will definitely consider the issue in question. We'll also consider the overall situation of the building. If the power company or the EMSD, having considered the overall situation of the building, is of the view that the building cannot accommodate any more basic housing unit, and that's another issue, because just now another member asked whether it's a first come first served approach, and that member also asked too many basic housing units may cause a major problem to the whole building, and that's really also one of our considerations. Apart from meeting minimum requirements, we'll also consider other circumstances in recognizing BHUs, such as the conditions of the buildings, and like the member said, perhaps the plant room capacity of the building has been reached, and that the EMSD of the power company will ask us not to recognize another BHU. Ms. Doreen Kong, thank you, Chairman. I want to emphasize that please don't take the first come first serve approach, because it's my basic right as a property owner. According to the DMC, I have the right to use my property, and if you use a first come first serve attitude, you are depriving other property owners of their legitimate interests. I want to supplement another point, Chairman. In my letter, I also referred to the issue of DMCs, and I agree strongly with Dr. Starry Lee that we cannot just simplify the problem and ignore what's glaring. As the owner, of course, you're responsible for any issues. But Chairman, when it comes to the last exercise on regulating SDUs, the government did not take up a very major role. But frankly, when it comes to basic housing unit and the recognition regime, the government actually intervenes quite heavily. It takes up a larger role. But what's more important is that basic housing units would affect the other flats in the same building. I can't just recognize BHUs and then ignore the problems in other flats in the building. Say, for example, as I mentioned in the letter, there is an apparent clause that the flat must not be used as an apartment house. There should not be any alteration of sewage, drainage, without the approval of the management company. And there are also other restrictive clauses on structural alterations, etc. I've also seen a DMC of a building stipulating that there must not be additional households or flats in the building. So that's very specific. When you talk about checks to be conducted by professionals, I think that at least professionals should be engaged to check the DMCs. Owners cannot fully comprehend the DMCs themselves. And then also in the application, in the forms, like Dr. Starry said about water seepage, I think that at least the property management companies should be engaged as well. Ms. Wong. Thank you, Chairman. Thank you, Ms. Kong, for the number of questions. About first come, first served, I think it's the members who started using this term that I followed. In recognizing BHUs, we of course consider the circumstances of individual cases. Apart from checking the BHUs for compliance, we also check the general condition of the building. Say, if this building already accommodates a lot of subdivided units, and that there is a sentiment among other owners that other SDUs should not be accommodated, then that's something we'd consider. And if you want to operate the basic housing units, when you submit the applications, you need to check the general conditions of the building. For example, whether there are already many basic housing units in the same building, because this is something we'll consider. Second point about DMCs, we already have a lot of discussions on the matter. It is the owner's responsibility to check whether the BHU operation is in compliance with the DMC. But we note members' comments. In the future, in the application form, perhaps another question will be included, and that is the owner will need to talk to the management office to ensure whether there is to ascertain whether there is any other restriction. As for the condition of other flats. The fact is, every building comes with its own DMC. On the whole, from the government's perspective, we believe that is for the BHU operator or the owner to bear this responsibility. Next, Dr. Starity. My comment is this. My understanding is that the owner's rights should be protected. And in the town planning procedures, let's say a first come first serve approach is also adopted for wholesale conversion of a building, for example, because everything comes with a limit, even for old buildings, be it power supply, loading, or whatever. Unless you're able to boost the overall capacity of the building, there must be a limit because safety is of paramount concern. Many owners are very concerned that if you continue to add more subdivided units to a building, then the loading capacity may not be able to cope. Just like a dozen years ago, there was a building in Hong Kong, and I checked that case. I think safety is of paramount importance. The other point is that for DMCs and water seepage, I think you should consider putting another entry. You can just ask the applicant to tick a box whether they have checked the situation together with a professional or consultant or the management office. If there is a contravention, it doesn't mean that the recognition will not be given. It's about a balancing of the interests.
Thank you, Chairman. The comments of the members will be taken into consideration. You still have time. All right. I want to ask about the electricity meter because right now the installation of each meter needs to be inspected by CLP. If there are already 7 meters, if it is already being overloaded, then why would it still be allowed? We have been in communication with the power supply company. We do see that many STU have claimed to have electricity meter. Those meters are being installed by some construction workers, and it is out of the initiative of the owner, him or herself. As confirmed by the power supply company, they said that if it is a proper meter, it has to be installed by their own electricians. And because if it is going to be installed by the power supply company, there will be proper testings in place. Can I understand it that way? The meters that are now installed is not necessarily being installed by the power supply company, but it will be so in the future. The existing meters installed are illegal. The power supply companies have installed meters in order to charge electricity bills of the SDU. Properly speaking, the power supply companies do not allow them to sell out electricity within the SDU. Let's say if the owners installed meters on their own within the SDU and charge the residents, if the bill of the self-installed meters is different from the proper electricity bill, well, certainly it's going to be different because as far as I know, the owners will charge whatever they want. It is illegal. If the electricity meters has to fulfill our standard, it needs to be installed by the power supply company. If that is the case, then the owner or the residents of that particular subdivided unit will receive an electricity bill from the company. Can I confirm that all the meters in the future need to be confirmed by the power supply company? We will not accept those kind of meters. Mr. Tony Chair. Thank you, Chairman. Well, it is me who mentioned about first come, first serve. I may not have been as eloquent as I should be. It can be rather rough. I don't want to cause any legal dispute, but you need to fulfill the minimum requirement if you need to be legally recognized, including the power supply. In the past, there have been a lot of replacement, but it is because there has been high demand. But now, if you're going to replace them, are you going to replace all the other existing SDU in the same building? It will cause a lot of disputes. Well, but I have another question. According to the government response to the meeting of the 21st of July, 8:30 a.m., I see that there have been some exemptions. I hope that all the law enforcement parties will be in alignment. In paragraph 10, they have mentioned about some small residential area. Basically, they do not have the approved plans by the buildings department. If that is the case, then the land registry will have some additional works. Otherwise, all the SDUs will move towards those kind of residential areas. I also believe that the professionals needs to be aware, because the more responsibility they need to shoulder, the higher cost they will charge. Or if they need to protect themselves, then they will always say, oh, you cannot fulfill the requirement. Is that what we love to see? I believe that there needs to be a balance. As I mentioned, all ordinances is all about being pragmatic. We have to first replace those that are worst. I hope that our government will not sit on the hands. You have to take some actions, but since this is a policy that is going to impact money, I hope that you can do it face by face. And it also needs to be implemented in line with the supply of public housing units. I hope that we don't have to wait until 2048 in order to eliminate the unacceptable situation of the SDU. Ms. Wang, thank you. I do agree with you. Substandard SDU is quite a thorny issue. Therefore, we have to be pragmatic in our approach. As I mentioned previously, the law enforcement has been headed up by the working group to tackle the subdivided unit, which is headed by the Undersecretary for Finance. After the implementation of the regulations of BHU, the buildings department needs to enforce the law, and the land registries also needs to take care of the situation of the small houses. Different government departments will set aside resources so that we can join efforts together and resolve the issues of SDU. Truly, the professionals have their own responsibilities. We do need to strike a good balance. We are aware that many owners are concerned about the additional cost under this new ordinance. If we add the responsibility of the professionals, then they will just charge more for the authorization. And what they need to do is to prepare the report according to the minimum standard. In the application form in the future, we would require the landlord to understand about the DMC from the management company. So we try to separate responsibility between different parties so that the implementation of this ordinance will be smooth. Reverend Peter Kuhn. Chairman, many are concerns about the supply of housing units. We are worried that there might be a shortage of supply because of the strict requirements. One reason is about the requirements of electricity supply. Originally, we see issues of the abuse of power charge. I just wonder about the requirement of the power supply company. When you first introduce it to us, you expect that there will be 30 SDUs that are substandard. But as I heard from you just now, you are not so certain. You know, those aged buildings might have a lot of split meters. some will not be able to fulfill the standard. If that is the case, then you might have more than 30%. It might be up to 40 or even 50%. Well, the result would be the increase of price, and we will also have problems allocating the residents that can no longer rent those SDU. It is positive for you to have high standard, but we still need to be practical. The issues of power supply is something that we need to carefully consider. Can we not put in the provisions that it must be installed by the power supply company? Can you just require them to have individual meters and to ensure that the billing is fair? Well, because the power supply company will not compromise any safety issues, they might need to be approved the increase of loading with the approval of the owners' organizations. I'm not asking you to lower your standard, but maybe the power supply company will have to inspect meter by meter. My worry is that you will not have 70% of SDU that are up to the standard. Thank you, Chairman, and thank you, Mr. Peter Kuhn. Let me remind you of our original intention. The proposal of having individual electricity and water meter is to prevent unfair charging. The installation of individual electricity meter is the requirement of the power supply company, and those meters has to be installed by them. Now, you are suggesting if we can allow the owners to install their meters without the involvement of the power supply company. If that is the case, my question is, how much does the person who installed the electricity meters know about the overall electricity loading of the whole building? How serious are they? If we allow them to have a meter that is not installed by the power supply company and we give them the recognition, would I be causing issues of the power safety of the whole building? And that's why we have to be quite firm here. It is actually an existing requirement. The meter needs to be installed by the power supply company. We're also concerned about the overall supply. Now we see that there are 30% that are substandard, but we do have 4 years of a transitional period. Then gradually there will be some existing units that is properly revamped, and also there might be some new BHU entering into the market. We are also concerned about the tenants living in the SDU. Among the 110,000 SDU, 40% of them are already applying for the public housing units. 20% are qualified but have yet submitted their application. All in all, we have 60% of tenants in SDU will be moving to the public housing. So the remaining are about 30 to 40,000. They can have the options. They can choose to remain in the BHU market. As we look at the overall demand and supply, we believe that we can gradually adjust the situation. Our requirement of proper electricity meters will not just disqualify all the suppliers. I note your concerns. Getting this ordinance passed is just our first step. We still have a long way to go. We will adjust ourselves in a timely manner, and we will have good communications with all of you in our adjustments. That has always been the way that we propose our policies. As mentioned, we have 4 years of grace period. Hope that we can join efforts together and do it well for the public. Mr. Andrew Lam, I just have a simple question. As Ms. Wong has mentioned, we need to adjust our methods according to the situation, and there is a 4 years of grace period. I think the overall direction is to replace the 30% of the substandard SDU, and we also need to secure the supply of the remaining 70% of SDU. We also need to concern that the tenants of those 30% of substandard SDU will not move to live in somewhere that is even more substandard. I hope that we have more accurate statistics, including the water and electricity meters. From my experience, I doubt if the statistics are accurate enough at the moment. Ms. Wong, thank you, Chairman, and thank you, Mr. Lam. I really appreciate all the thoughts that you have shared with us. By 1st of March 2026, as we rolled out the registration system, I hope that we would be able to understand the situation of the existing 110,000 units. We have done some survey previously. The results that we have from the statistics department is actually similar. As for the internal situation of each SDU, well, I believe that we will receive more details as we roll out the registration system.
Members, I'm beginning to feel that members are circling back to the policy issues, and some members have asked questions for 4 rounds already. I do think that we need to reserve some time for the administration to go through the committee stage amendments with us. So please observe that and support my decision. Dr. Starry Lee. I think members all agree with what the DS said, and that is the legislative intent is to eradicate substandard subdivided units. But we need to ensure safety in the eradication process. We're not enacting a new piece of legislation for something novel. We already have over 100,000 subdivided units in existence, so we need to be pragmatic. For example, I talked about the Fire Services Amendment Bill. It was passed some 10 years ago, but it couldn't be implemented because of practical problems. So likewise, I hope the administration would consider taking a pragmatic approach whilst striving to meet the objective of eliminating substandard subdivided units. The situation is quite complex. On electricity meters, I'm of the view that this is a tricky issue. It's for the power companies to install meters, and then you mentioned that 70% of the units should meet the requirements. So it's a balancing exercise for you, and Chairman, I do look forward to the timely passage of the bill, so perhaps I'll stop here. Ms. Wong. Thank you, Chairman. Thank you, Dr. Starry Lee. I fully agree that we're taking this very important step towards eradicating subdivided units in Hong Kong. I mean substandard subdivided units in Hong Kong. But this is no easy task. We'll have regard to the actual circumstances, and before we propose the minimum standards, we've actually conducted sufficient consultations and studies. So please understand that we're talking about the bare minimum for ensuring a safe living environment. And about electricity meters, rest assured, we do aware of the difficulties. We have not underestimated the problem. We have been talking to the power companies, and they have ordered a new consignment of electricity meters. What you see in the market at the moment are not in perfect compliance with the law. There is a need to install new ones in order to meet our requirements. Members, we should now move on to the CSAs, and that's CB bracket 11267 / bracket 05. Perhaps I'll invite the administration to walk us through the paper. Mr. Chan, PAS. Right, let's go through the paper paragraph by paragraph. In the second paragraph, we have listened to members' views and the advice of the legal advisor of the Legislative Council. We've proposed 5 items of amendment. For the first one, in light of members' views, we propose to delete premises of the building so as to improve the drafting of the provision. Any questions? Let's pause here. I think that this is a response to the members' suggestion last time. Next, still on clause 2, subclause 1. We consider that the title register is already defined in Cap 585 in the Land Titles Ordinance. We agree that the rather cumbersome expression should be paraphrased, and that means we are going to make an amendment to improve the drafting by directly referencing the term to the Land Titles Ordinance for the definition of title register. Any questions? If not, let's move on. Item 3. Now, for circumstances relating to refusal to recognize a BHW, cancelling of the registration, etc., etc., the Secretary is empowered to take action on the above scenarios if he's satisfied. And we add the phrase on any other reasonable ground to capture these scenarios. Any questions? No. Next, clauses 38, 39. We've considered the legal advisor's views, and we stipulate in clauses 38, 39 that the authorized office persons must not request any person to provide information or documents which may relate to the legal professional privilege to ensure that the LPP is respected. Next, clause 47. To avoid ambiguity, we add the definition of legal representative in the interpretation clause of clause 47. Any views? Any other questions? If not, Mr. Chan, I think we've covered all the proposed amendments at this stage. There's another one in paragraph 3 of the paper. Having considered members' views and the legal advisor's views, we also propose the following amendments. In clause 79(4), we originally added a definition for clause 39 warrant. Since the same reference appears in clauses 79 and 80, we propose moving the definition of this term clause 39 warrant to clause 2(1). Next, in light of the amendments to clauses 38, 39 to give protection for a person to provide information or documents which are protected under the LPP, we also amend 36(2), and that is 36(2) relates to the Secretary's power to request for the submission of documents. And then point C, this is a response to the issue raised by the legal advisor about entry into premises for a search or inspection. The original arrangement is that only if the entry is refused should the officer apply for a warrant. Now we've considered the circumstances, and that we have decided to add here that if the government is unable to get consent from the occupier, the government can apply for a warrant with the court. apart from the fact that we may not be able to get the occupier's consent, there is also reasonable suspicion that an offence under the ordinance has been committed. So this is an enabling provision. Any other questions? If not, then members, I think we have covered the other part to our discussion today, and that is about the proposed CSAs. And I see that basically the administration has responded to all the issues raised, save for one thing, and that is in light of Reverend Peter Kuhn's suggestion whether it is necessary to take out insurance policies relating to the premises. Can you give us a reply now? Well, I think I can give you a very clear reply now that this will not become part of the ordinance, but we will include the detail in the guidelines to be issued in the future. Okay, I don't think Reverend Peter Kuhn has any strong views on this matter. I think we have discussed all the written responses and the proposed amendments. Anything else from members? If not, I'd like to seek your views on the following housekeeping matters. First, the Secretariat issued a circular inviting members to propose amendments if necessary. The deadline was actually yesterday, and no member indicated they wished to move any amendment to the bill. So would members please note that? Legislative timetable. As I understand, the administration would like to resume the second reading of the bill in the second half of September. Is that right? Ms. Wong, anything to add? Right. Next, AOB. Anything under AOB? If not, meeting's adjourned. Thank you.